email for notification of certain award. And I also had in JP that is number JP number 50/2021. So my number is both the maybe out together. Any paper.
Have you informed Mr. Patel?
Yes. I have not yes. And copy has already been served.
Learned counsel for the opposite party, Mr. M.V. Lal submits that civil review 50 of 2021 referred by the opposite party here against the same judgment.
And both award. On award for modification of decree. This year, I think this for modification earlier.
Arising out of the judgment passed in civil review.
Yes.
Number be also posted along with the instant petition. Mr. Pratyush Kumar and counsel for the petitioner is present and submits that copy of the civil miscellaneous petition has also been supplied to him. What is civil review number?
Arbitration appeal number 7 of 2020. Arbitration.
आप रिव्यू के अगेंस्ट में जो डिक्री प्रिपेयर हुआ है उसका concerning the same subject matter. You both of the sides will not allow this litigation to rest, no? How old has he become now? 87, 88. As Fred Forless the case, both the cases together in the next week. Friday won't be possible. There are already fixed matters. This has been taken up earlier.
No, that's all been taken up earlier.
No, not admitted or LCR. And provisional or final?
No, final. The notification has to be made up thereafter.
Very well. Then list it on this Friday. In the HD matters listed today from the ACI, instructions are there about half custody starting from serial 2 onwards. Do you have the instructions?
Yes, my lord. In some cases, we have the instructions.
That means
some cases, inspection has also been carried out by both the parties.
Today's list?
No.
Okay, so you agree that some of them have completed half custody.
No.
Which are the serial numbers indicated so that we can take it up?
My lord, serial number 3, 4. Criminal appeal is Rajendra Kumar Khalid.
Very well. Then?
And my lord, criminal appeal SJ 154 of 2022, Kalitesh Prashant.
Yes. And?
Mukesh Kumar Srivastav.
Very well. Then?
Arjun Sharma.
Okay.
Then Shyam Nandan Singh is for confirmation of provisional.
Okay.
And
so except serial 3.
So that is for modification.
Oh, that is for modification. So rest, all half custody is there.
My God. In one case, as per our instructions, half custody was not complete. However, in the joint inspection, it has come that.
Okay. So you are going to accede to their claim that they have custody.
My lord, it was a joint inspection.
Right. So we may straight away take up after serial number 1 the fraud scam matter. Serial 1 corporate.
For orders, item 1, CP number 2 of 1996, Mr. Himanshu Kumar Mehta for the petitioner.
There is one IA filed by BSIDC. Intervention we understand to participate. participate in the bid, but the IA by BSIDC is by you.
Yes, sir.
So is there any change in legal position as to the transfer of pending company petition?
You got it. Now, the school has stated that the school has stated, and it is that during the ministry of the CP also in the board desire, in the honor was that transfer to the NCA. So in this case, I have played this to the if the option continues in option, it's like the words of whether the option purchaser are here or not. That's why I highlighted.
Which paragraph of the apex court order which you have annexed? देखिए जरा इसको ऊपर। Straight away come to the paragraph.
It's starting from legal case 24.
Which is the paragraph?
Where the company has been resolved, the resolution is
Page 61.
There also on the last page also the official liquidator has filed IA that in the name nobody has turned up. So I filed this IA because
The legal position has been examined by us when this IBC code came into effect, and this plea was raised by some of the secured creditors or others also. So the legal position was quite clear that transfer of pending proceedings is not mandated under this. So where is the hint by the apex court that at this stage also transfer can be done? Is there any observation to that effect? So let me first understand on what legal basis or observation of the apex courts is trying to rake up this issue after 6 years of the IBC code. नहीं वो ठीक है, आप वो पैराग्राफ पे आइए ना जहाँ से आपने
There a company, number 25 on page 6. There a company has been resolved. The resolution may be stated that in a period of 2 years from the date of the resolution under section 6 of the company act 2013. Given the requisite scheme of filing under chapter 20 of the Companies Act 2013, it is clear that several states have legislated interpretation against the power to control the proceeding in a binding application even after it is regulated. Thus, in a binding of proceeding where the petition has not been served in terms of the Rule 26 of Companies Code 1959, at the pre-admission stage, given the beneficial result of the application of the code, such binding of proceeding is compulsorily transferable to NCLT to be resolved under the code. Even post issue of notice and pre-admission, the same result will issue. However, post admission of the binding of petition and after the essence of the company sought to be owned or becoming custodial vacates and not taken over by the company liquidator. Section 290 of the Companies Act 2013 would indicate that the company liquidator may carry on the business of the company so far as may be necessary for the beneficial binding up of the company and may even save the company as a going concern. As long as no actual sales of the individual or movement properties have taken place, nothing irreversible is done, which would warrant the company board staying its hands on a transfer application made to it by a lawyer or any party of the proceedings. It is only where the binding of proceedings have reached a stage when it would be irreversible, making it impossible to set the clock back, that the company board must proceed with the binding up. Instead of transferring the proceedings to the NCLT to now be decided in accordance with the provisions of the code. Whether this stage is reached would depend upon the facts and circumstances of each case. In the facts of the present case, the deadline binding of the company and the decision takes despite the fact that the liquidator has taken position and control of the registered office of the active company and its active premises, records and books. No irreversible step towards finding out the active company has otherwise taken place. This being so, the company code has correctly exercised the discretion vested in it by the fifth proviso to section 454 reservatory is given to the arising out of SLP number 12 for standards.
Section 4. This is going on under the Companies Act 1956.
Paragraph 23, at page 14 of the annual, I have upon the whole section 434 of Companies Act 2013, which gives me the transfer of certain benefits.
This judgment which you are relying upon is under the New Companies Act or under the Old Companies Act?
It's the rules companies and industry companies are 2013, but at the foot of it, actually the provider has it as proposed in paragraph page 17 of IE that all proceedings under companies are 1956 other than the changes relating to writing up of the company that are reserved for orders for allowing or otherwise such proceedings go on. The proceedings relating to writing up of the companies which have not been transferred from the High Court stand within accordance with provisions of the Companies Act 1956. Provides also that the proceedings related to make a voluntary writing up of a company, the notice of the resolution that advertisement has been given in a subsequent section 1 of section 485 of the Companies Act. But the company has not been resolved before the first April 2017 and continues to be dealt with in the accordance with provisions of the Companies Act 1956. The central government will make rules consistent with the provisions of this act to ensure timely transfer of all the matters, proceedings or cases pending before the company law court or the court with the regular agreement.
प्रोवाइजो आपने पढ़े हैं सेक्शन 434 सी के बाद सेकंड प्रोवाइजो आप लोग एक देख लीजिए जरा and give a response because one of them has filed a petition. ये this is under 1956 Act. This first of all this is under 1956 Act.
Yes.
Started in 1996. Now,
one secret data SBI approach to the NCLT under the Bank Scheme rules 2016, in which it has been ordered that you can refer approach to the airport dispatch.
And thereafter, Section 434 of the Companies Act 2013,
Yes.
which has been referred to by the Apex Court at page 63, if that is also referred or relied upon, then there is a proviso. You have Companies Act
Yes. Yes.
2013. Mrs. Sanchita, Section 234 do you have? Sorry, 434 do you have? तो आप देखिए उसका C के बाद the fourth proviso. Provided also that this has been instituted with 29 June 2017. Provided also that all proceedings under the Companies Act 1956. Do you have that?
Yes,
This is from the start. It is the fifth proviso. Provided also that all proceedings under the Companies Act 1956, other than the cases relating to winding of companies that are reserved for orders for following or otherwise such proceedings, this doesn't apply. Small 2, the proceedings relating to winding up of companies which have not been transferred from the High Courts, matlab, not from the High Courts,
Yes.
shall be dealt with in accordance with the provisions of Companies Act 1956 and the Company Code Rules 1956.
Yes.
You are therefore relying upon the judgment which is dealing with the provisions provisions of 2013 Act. And 2013 Act Section 434 1C contains a proviso which makes the position clear, exception to the main proviso.
And that too at the last.
At the fag
At
end.
the end of the estate period.
Fag end.
Auction is going on.
Fag end.
Other judgments are also, I am proud that therefore,
So you reply to this IA.
in that case also, we will do that. There
We
is
will-
no situation.
We will set at rest this issue, whether it has to be
Case is
transferred.
completely different.
That's why I think I was just to assist the court on the point that because there are no serious option for change of before you ask.
No, your intent might be good, but at this stage, in view of the position in law, both the IBC code and the act under which the liquidation is winding up is going on, and the new act of 2013, whether
With rule 16, 2016.
read with that rule, whether this at this stage it can be transferred or not. Once you have filed a petition, the court can't ignore it.
Yes.
You will have to settle the matter on that. So, one new bidder is filing an IA. Very well, very well. Keep yourself interested for the time being till we decide this IA. Your claim is, so your claim stands. And Mr. Mehta, any other bidder who has turned up after the reminder?
Okay, so we come from the
All are, they are not deposited in the draft. From there, we can, intention of the bidder should come before the court. And all are saying about the,
The official liquidator, the OL will look into it and give his view.
they all are asking with regard to the bank guarantee. And this, I'll see what the bank guarantee. The new information is also asking for the bank guarantee. This is not the policy in the system.
We submit a draft of such a 3 months it lapses. Again, a fresh draft. So financial bank guarantee, I'm not giving a performance bank guarantee.
So in case you are willing to furnish a financial bank guarantee, you may as well furnish a demand draft also, because once there are more than one bidders, then most likely the auction would proceed.
Yes,
And it won't take more than 3 months for your demand draft to get expired and lose its validity. So wait till they respond now. You have come after a cutoff date. So then the court will have to take a view and entertain those coming after the cutoff date, whether it is good in the larger interest of the winding up of the company or not.
I will decide whether I
at this stage, whether it is permissible or according to law is for the interest of justice also. Because the matter is 1996 time sensitive. If it is remanded to another court in that state, that will be completed the right court. Whatever is my apprehension. Therefore, how the matter
We
will be
understand the concern more than any of the parties. It is the court.
Yes, madam.
Mr. Mehta, that 1956 CP is also pending.
Yes,
CP is accountable. So many persons has minor.
That's the oldest case.
So,
Oldest case of company petition in any high court pending.
and it is the condition
It's the
of
only
government.
the National Judicial Data Grid that is blinking like this.
Oldest case. Before the High Court.
IA number 3022 of 2022 has been preferred by Bihar State Industrial Development Corporation. Secured creditor. Here to secured creditor. Shareholder. With a prayer to transfer the case records of this petition to the NCLT Kolkata in exercise of the discretionary power under section 434(1) small c of the Companies Act 2013. Stop. Para. Then counsel for the TSIDC has referred to a judgment of the Apex Court dated 15 December 2020 in Civil Appeal number 4041 of 2020, Action Ispat and Power Private Limited versus Shyam Metallics and Energy Limited. Stop. Then counsel for the official liquidator, learned senior counsel for the secured creditor, Bank of India, and other parties are allowed 2 weeks' time to file response positively. Let the matter be listed on the Friday in the reopening week after summer vacation 2022. Stop. IA number, उसके बाद लिखिए. IA number 3137 of 2022 has been preferred by a person, company. Yeah, what is the name? NR Infotech Company Limited Company, with a prayer to allow it to participate in the auction process. Stop. Then an official liquidator would also respond to the said item. Mr. Abhay Prakash, then counsel appearing for another bidder. You had applied before cutoff? Al Sifa Company Minerals submits that the bid of the said company is also still interested in the bidding, in the auction process. Stop. Let the matter accordingly be listed. Give your slips.
Address. Item 2, CMP number 238 of 2018, Mr. Rohit Ranjan Sinha for the petitioner.
Order dated 10th of December, my lord, has given me an authority to take steps for paper publication license.
Yes.
The format for which I received on 11th of January, my lord, of 2022. But due to sudden rise, I could not take timely steps for paper publication, my lord. So I'm requesting one more opportunity. Within a week, I will take appropriate steps. Requisite have been filed, my lord.
When has the requisites been filed?
But in December 21. We got the order number.
So, fresh draft of notice need to be issued with a fresh date. And counsel for the petitioner submits that because of some delay due to COVID situation in filing the requisites, fresh draft notice needs to be issued by the office for compliance of the order dated 29 January 2021 and 10 December 2021 in respect of service of notice on OP number 2 and 3 through paper publication. Stop. Office to issue fresh draft of notice by 10th of May 2022. Then counsel for the petitioner to collect the draft of notice from the office by that date positively. Supplementary affidavit be filed showing service of notice within 3 weeks thereafter.
Item 3, criminal appeal 94 of 2022, Mr. Abhishek Kumar.
This IA is by whom? So what?
Modification of order is 422, that's with respect to the deposit of so that the recovery grant based on I wanted to see base 422. And the direction was given by the commission for depositing the amount of 15 lakhs with the idea. So that the total that the teacher is concerned of data and the property was not and the copy of the teacher was not and attached to the direction to take in the and so far as the other source of income are concerned, that was not sufficient. And therefore, one of so far as the petition has been filed. Previously, lordship has allowed for so far as the amount of fine, the condition for the depositing amount of the capital is and by 1. There is also an amount of fine was 1.5 crore and 1 crore, which has been reduced. Therefore, the these are already executed here over even without these non-regulations or
How much is the appellant willing to deposit as the fine amount?
that means about 3 lakhs over that.
Yours was the maximum fine amount ordered by the court, lower court, 1.5 crores. You deposit at least 5 lakhs. All that is good. Whatever which will be. Condition of pre-deposit of fine amount for getting the privilege of suspension of sentence, it is within the discretion of the court. So there is no quarrel on that.
Therefore, I am not happy with it.
To deposit 5 lakhs. IA number 3719 of 2022 has been preferred for modification of the condition relating to deposit of fine of rupees 15 lakhs or imposed by the order dated 8th April 2022, granting the privilege of suspension of sentence to this appellant in connection with the instant conviction in RC 47A/96-PAT. And the senior counsel for the appellant submits that the appellant is aged 82 years and suffering from various ailments, including pituitary macroadenoma with hypertension, hypothyroidism, diabetes type 2 with cervical and lumbar spondylitis, and is a critical patient of ischemic heart disease. Stop. The appellant has not been receiving any pension since last 16 years and all his savings have been exhausted. Stop. His properties, including that of his family members, have been attached by the CBI in miscellaneous case number 145 of 96, and as such, the appellant could not furnish bail bonds for his release due to inability to deposit the fine amount of rupees 15 lakhs as ordered by this court. Stop. Appellant continues to languish in jail despite privilege of suspension being granted on 8th April 2022. Stop. Appellant could not attend the funeral of his sister-in-law on 20th April 2022 as he could not be released. Stop. Then counsel for the appellant submits that in such circumstances, the privilege of suspension of sentence and the liberty granted pursuant thereto to the appellant cannot be availed unless the fine amount is suitably modified. Condition of fine amount is suitably modified. Stop. And then counsel for the appellant submits that this court may therefore reduce the fine amount, condition of deposit of fine amount as may deemed fit and proper. As may be deemed fit and proper. Learned ASGI has opposed the prayer. Stop. He submits that the appellant was the regional director, assistant director in the AHD, during which period huge fraudulent withdrawals had taken place with his active involvement in conspiracy with other suppliers and officials of the AHD. Stop. I have considered the submission of learned counsel for the parties and taken note of the grounds urged in the instant IA. Stop. It appears that on account of non-deposit of the fine amount of rupees 15 lakhs, appellant is still languishing in jail, though bail was granted. Though sentence was suspended by order dated 8th April 22. Stop. Having regard to the totality of facts and the grounds shown by the appellant, this court is inclined to reduce the fine amount. The condition of fine amount imposed in the order dated 8th April 2022 to rupees 5 lakhs. Stop. IA number so and so is accordingly. Let the order dated so and so be read along with the instant order. Stop. IA number so and so is accordingly disposed of.
Item number 4, Criminal Appeal 142 of 2022. Mr. Vishnu Kumar Sharma for the.
How much is the custody, Mr. Pallav, according to your?
Joint verification carried out by it comes to 2 years, 3 months.
2 years, 3 months.
Yes, sir, because that was not a good backup. It was graduated.
Give it. In a slip you give it. With which page is your?
Page 447.
Page 447.
447.
Rajendra Kumar Harit. Third paragraph में लिखिए. Then counsel for the appellant submits that the appellant was proprietor of a transporting firm, Mrs. Pooja Road Lines Ranchi, against whom the CBI alleged transportation of materials relating to AHD booked by the suppliers to the tune of rupees 1,23,90,793 without actually transporting the materials. The counsel for the appellant submits that the findings of the learned CBI court are regarding the appellant A102 within bracket are contained in paragraph 291 and 292 of the impugned judgment. Stop. The learned CBI court has, on the basis of certain prosecution witnesses, come to a finding that circumstantial evidence is enough to establish that appellant was in conspiracy with other accused persons and fraudulently withdrew government money from the treasury. Stop. And counsel for the appellant submits that any defense statement that you have.
Because only one thing, because there is no evidence on the court to suggest that the materials have not been transported to the end.
It is submitted that apart from the prosecution witnesses named therein, there are no other evidence to show that the materials were not transported. Stop. The findings rendered by the learned CBI court is therefore based on erroneous appreciation of the evidence on record. Stop. It is submitted that the appellant, how old is he?
So it's 61.
Appellant has undergone custody of about more than 2 years against the maximum sentence of 4 years under different provisions of IPC. Stop. Therefore, he may be enlarged on bail by suspending the sentence. Learned counsel for the CBI, Mr. Prashant Pallav, has opposed the prayer. He submits that the evidence on record produced by the prosecuting agency has been able to successfully establish through only oral evidence is there in this. There is no mention of any documentary evidence.
There's no documentary evidence. Only the witnesses are come to prove that they were the owners of the truck and that
such as PW 235789 and others clearly fully established the charges against the petitioner during trial. Stop. Then counsel for on the claim of custody of more than half of sentence undergone by the appellant. However, he submits that the joint inspection of the lower court records, including the order sheet conducted by both the parties, by learned counsel for both the parties, including the officer of the CBI.
The supplementary is also being filed with respect to, and she will attach 5 copies of the.
However, go to show that the appellant has completed about 2 years and 3 months of custody, which is more than half of the sentence. Stop. The details of the custody period are being submitted in the form of a chart by learned counsel Mr. Pallav, which is as under. Stop. Learned counsel for the appellant submits that a supplementary affidavit has been filed enclosing the order sheet of the certified copy of the order sheet of the case, RC case, to substantiate the claim of half custody. And the breakup has been given at paragraph 8 thereof. 9, no? 8 and 9. 8 and 9. Achha, 9. Stop. I have considered the submission of learned counsel for the parties and taken note of the materials relied from the reports, including the plea of the appellant that of having served more than half of the custody against the sentence of 4 years awarded by the learned CBI court. On considerations of the submission of learned counsel for the parties and the materials on record, including the fact that the appellant has undergone more than half of the custody, I am inclined to enlarge him on bail by suspending the sentence. What is the fine amount?
The total fine amount for 20 lakhs. 10 lakhs for substantive offences, 10 lakhs under 120.
2 lakhs, deposit 2 lakhs. Don't make such a mess. Eh? 25. 2 lakhs.
Item number 5. Criminal Appeal 154 of 2022. Mr. Vishnu Kumar Sharma.
How much is custody, Mr. Pallav?
Custody is about 2 years, 1 month.
2 years, 1 month.
And 5 years.
Where is it?
Dr. Maynard.
Where is the para
Matter
100?
is 299 and para 110. Serial evidence matter.
And any discussion thereafter?
311. School is assigned 299 and 300. And para serial evidence.
नहीं उसके बाद डिस्कशन और कहाँ हुआ है?
ये इसी
वहाँ तो सिर्फ
299.
that 299 is the list of medical officers.
Supply. The allegation against the elder visiting doctor and make name using a serial number 11. 11. Accused 127 Dr. Lester of that of former DPO Mumbai. Allegation without giving the clearance certificate or receipt of supplier bills without receiving the material. Allegations.
Learned counsel for the appellant, the third paragraph, submits that the appellant was the former TVOM, traveling veterinary officer mobile, Gumla, during the subject period of the instant AHD scam concerning fake and fraudulent supplies to AHD department at Ranchi. Stop. It is submitted that the main allegation against this appellant, like other such medical officers / doctors, veterinary doctors of the AHD department, is that he colluded with the accused suppliers and certified the fake invoices without any fake invoices for fraudulent withdrawal of huge amounts of money from the government exchequer without any, on the basis of forged allotment letters. Stop. It is submitted. How old is he?
They received the material.
Age.
Yes, that's 22 years.
The discussion about the role of this appellant and the findings against doctors of the AHD are contained at para 110 of the impugned judgment. Stop. The appellant is 72 years old and by now has undergone more than half of the custody against the maximum sentence of 4 years awarded upon him. Stop. Therefore, he may be enlarged on bail by applying the rule of parity vis-a-vis other similarly situated convicts / appellants who have been released on bail by this court upon completion of half of the custody. Stop. Learned counsel for the CBI who opposed the prayer, he submits that the appellant, being a veterinary officer of the SD department, was found to have falsely certified invoices submitted by, fake invoices submitted by the suppliers, though no actual supplies were made, leading to huge fraudulent withdrawals from Doranda Treasury without on the basis of fake allotments. Stop. Then counsel for the CBI, however, submits on the basis of joint inspection carried out. On the basis of instructions received from the CBI that the appellant has completed about 2 years, 1 month and few days as on date against the maximum sentence of 4 years imposed upon him. Stop. उसके बाद वही जो लिखाए थे वो लिखा I have considered the submission of learned counsel for the parties and taken note of the materials relied from the records, including the plea of having served more than half of the custody by the appellant, having regard to the totality of facts and circumstances noted above, and that the appellant has served for about 2 years, 1 month and odd days against the sentence of 4 years as on date. I am inclined to enlarge amount bail by suspending the sentence. 25,000 for sureties of like amount each. What is the fine amount?
2 lakhs.
2 lakhs. 50,000 of the fine amount. The rest of the conditions remain same. I have disposed of.
Item number 6, criminal appeal 171 of 2022, Mr. Vishnu Kumar Sabhi.
Same, para 110.
Same paragraph, serial number 23 matter. Is attended by former assistant director poultry farm, Bhopal.
Assistant Director Poultry Farm भोतवाल, वो पिछला ऑर्डर और इसमें सिर्फ इतना ही लिखा है।
Custody 2 years,
2 years 8 months custody.
instruction.
Based on instructions. और एज कितना है?
Age is 60 years.
एज वाला छोड़
Fine amounts for 2 lakhs.
50,000.
All this custody custody balance on the basis of 2 years. They won't cancel, they are after financial amount. All these three in fact. Year custody.
7.
Item 7, criminal appeal 173 of 2022, Mr. Vishnu Kumar.
This applicant was posted as former assistant poultry officer Jharkhand.
Assistant
Age 73
Poultry
years old.
Officer Chaibasa, aged 73 years,
On instruction 2 years 5 months.
2 years 5 months on instructions,
Not with
and odd days. Same way, para 110, same.
serial 22.
Serial 22. At para 110. Yes,
Item 8,
fine 50,000.
Item 8, criminal appeal 253 of 2022, Mr. Niru Kumar for the appellant.
इसी में आप आइए नहीं फाइल किए थे उस समय एक्सटेंड हुआ था कि फिर एडमिट हो चुका था prayer for confirmation of provisional bail granted to this appellant by order dated 15th February 2022 and extended by 13th April 2022 has been made through IA number 3049 of 2022. Supplementary affidavit फाइल किए हैं, उसके बाद conviction का यहाँ रिकॉर्ड लिखा ही हुआ है. Then counsel, where is the discussion about your
Page 391.
391? Then counsel for the appellant submits that the case of the appellant, role of the appellant, A48 within bracket, proprietor of Mr. Shyam Industries Ranchi, has been discussed by the learned trial court at paragraph 207 and 208 of the impugned judgment. Stop. It is submitted that the appellant was accused of having fraudulently availed payment of rupees 2,23,947 only as against the total supplies of GNC worth rupees 22,99,738 during the financial year 1990-91 and 1991-92. Stop. Then counsel for the appellant submits that considering the lesser gravity of the charges, the trial CBI court has been pleased to award a maximum sentence of 3 years under the impugned conviction, and also granted provisional bail by the order dated 15 February 2022, which may be confirmed. Learned counsel for the CBI has opposed the prayer. He submits that the prosecution has been able to successfully establish the charges based both on oral and documentary evidence as against the petitioner, who was the proprietor of a supplier firm. Stop. Having considered so and so, provisional bail is confirmed. What is the fine amount? Fine amount of 25,000. Deposit. I stands disposal. श्योरिटी तो नहीं रहेगा इसमें, क्योंकि वो पहले से दिया हुआ है.
For admission, item number 9, contempt civil.
Regarding the matters which are on 6th, joint inspection has been carried out. So, okay. So, just give a list of those cases in which you have, by joint inspection, found out as to have custody or not, whatever it is.
We'll look at today's.
Very well.
Item 9 to 12.
Personal appearance is there, non-compliance of order. If it has not been paid, the amount which has been recovered has also been not paid. Considering on the last of the last of the
Today, are they appearing?
Serial number 8 and 9 is, I just received yesterday a letter.
So this is concerning more than one department.
Yes, yes. Policy department.
I think 11 and 12 are kind of very well.
So in 631 relating to REO
Yes, sir.
and 313,
Are you aware?
the payments have been made.
Yes, the decision has already been taken, but you find an additional superfluous. This is the documents that were paid for allotment of fund. Decision has already been taken.
That you indicated on the last date
They
also.
are asking for a fund, and amount which has already been recovered. Yes, we are waiting for the funds.
Funds means allotment has been made in this budget, or you will have to wait for another budget.
From the new budget, straight to budget.
Why is the concern, actually who is the disbursing officer who is waiting for allotment?
The letter.
Deponent is who? Executive engineer. So, any official of the department, secretary or others are not party here.
The secretary of the party.
Secretary of REO is,
Engineering organization is a.
no, where is he? He is not the party.
Secretary, if any engineer, executive engineer, our party.
Then the secretary should give an affidavit as to why allotment is not being released.
The letter for allotment was already sent on, in 4/2022. That we are the next, for the last.
This officer who is standing behind is representing which
Our content is 6, 5 and 6.
so item 12 and 13,
Yes.
11 and 12.
11 and
Okay, that is forest department.
12.
Your any officer is also present.
No, but yesterday sent me a letter that he has some dental plant is there and is not able to appear as because of revenue. Send me a letter along with the.
Page 30 is the requisition for allotment.
Yes.
In contempt civil 313 of 2018 and 631 of 2018,
Page 29 and 30.
this court was informed on the previous date, 25th March 2022, that decision to make admissible payments to the petitioners have been made, but payments could not be made. Stop. Some time was sought to make the payments. By the supplementary show, additional supplementary show was filed on 20th April 2022, the opposite party number 4, Executive Engineer REO Circular Zaribagh, has sought some more time since request for allotment has been made through letter number 254 dated 16th April 2022 to the department, REO department. Stop. When counsel for the petitioner submits that the admissible payments have still not been made. Stop. Let opposite party number 2 or her successor in office file an affidavit indicating whether allotments have been made for payment of admissible amount to the petitioners in compliance of the order of under offence and in view of the requisition made by the opposite party number 4 within a period of 2 weeks. Stop. About your content?
One case is left over or that arguing matter. Proxy stack that matter also with this proxy.
At the end of the order indicate that. Mr. Yadav, what about your forest department?
Forest department, in that case.
Who is the officer concerned?
Authority officer concerned.
11, 12 का time. He is? कौन ऑफिसर है ये? हैं? He is opposite party number 6. And other two are not opposite parties. They have come along with him.
is there in 665 of 2021 is filed.
सीरियल नंबर से नहीं पता चलेगा, ऑफिसर का डेजिग्नेशन बताइए.
Designation is not elevator of
फॉरेस्ट बोकारो सर.
forestry circle, Bokaro.
And the third person?
And in 670, AFO State Trading Division Hyderabad.
Okay. So, what is the difficulty in complying with the order?
In this case, the MPA was dismissed for default. Thereafter, CSP was filed. It has been allowed on 26th. And the
Very good, but that doesn't stop you from complying the order now.
in that order, after the division bench, there is the state order is there.
No. In the LPA,
In LPA, the state was there. And since the case was dismissed for default,
where is the LP order?
so the LPA order is revision E1 page 27 of
Page 27. Your LPA has also
Super
been.
5 of 30th 11 2021 page number 27. your second page, since it has been on, it has been on behalf of the applicant that the information will be in the means of the or laid on the full range of this coding, mainly the transfer system of Bihar and others, and other those cases. The operation of the engine order detects will also cause the learning of the salary of details on the other sides. So, common order was asking.
So since January 2020, 6 January 2020, when the LPA was dismissed,
Yes.
till 26th April 2022, what was the reason for not compliance? Tell your officers not to become very wise. The court was granting time. One of your departments has complied with the orders. And you had stated that there are no clear instructions despite being in touch with the concerned officials of the forest department. Now the department officials of forest are coming up and saying that since the restoration has been allowed, therefore they will enjoy the stay of that order under offense.
But the department has instructed them that we will take for the outcome of that.
One can understand what the department has said. You need not repeat that. But what was the explanation for 6 January 20 till 26 April 2022? You took the indulgence of the court for granted, and when one of the department has complied with the order, you complied.
The order is in the appearance of other side. When it's here, so in LP we are the parties we have appeared. So the state comes to end the moment we have appeared. The last line, the remain state till the appearance of other side.
You have already appeared.
We have appeared and we have then going to dismiss what we call. So that state is not there now.
Notices could not be issued to the concerned respondent, and there was a delay of 4 days in filing the requisite one. That is why the LP.
वो सब तो हमारे देखने का काम है. वो तो आप LPA में explain कर ही चुके हैं, and the court being satisfied has restored it. But the order of stay was conditional till appearance of the other side. You have not sought any extension of the interim order in the order restoring the LPA. फिर क्यों इतना मेहनत कर रहे हैं? Order comply करिए and subject to outcome of LPA. When your other sister or other department has complied with the order, आपका भी LPA dismiss हुआ था.
Same matter dismiss.
तो बताइए, अब ये how is this stand? इतनी सिंपल सी बात है. The government of Jharkhand becomes a split personality. Huh? Yeah, when Mr. Yadav appears, then he takes a totally different stand. बोलिए नहीं तो फिर हम लिखाएंगे सारा जो order was conditional. They have not sought any extension of the interim order in the restoration. आप तो कंप्लाई ही नहीं कर रहे थे, कुछ न कुछ बहाना बना करके पेंडिंग रखे हुए थे. The court was granting you indulgence in full faith कि आप कम से कम वहां से डिसमिस हो गया है तो इधर तो कंप्लाई करिएगा. और आप ही के एम्प्लॉई हैं, वहां सक्सीड कर जाइएगा तो फिर रिकवर कर लीजिए. The court never likes playing with the court.
No, regarding that,
Last 2 years. This last 2 years. The officer has given enough time to them. More than 50-20 times as between 2 years.
we will take decision on that subject to outcome
अभी
of
भी
the
decision
But
decision
that
लीजिएगा.
decision has not been taken by the department as yet. I have to find college.
They what the why
find proper so-called
the officers come to the court just for a pleasure in a contempt matter, leaving their official duties.
there was a direction.
No officer, no. The direction was conditional. Never there is a direction by me, at least. If you comply, what is the necessity of coming to the court and wasting the whole day when you could have performed your official duties? Okay. On the part of the officials of the so and so, give the appearance slip. So and so, so and so, so and so have appeared, who are officials of the forest department, which is also covered by the which are a forest department, which also are covered by the common judgment under offence passed by the writ court in a batch of writ petitions. Stop. You have not filed any show cause to bring on record this order. No show cause has been filed.
I was expecting that this matter will come on 6th, therefore, so
How?
not been prepared.
There was no date fixed.
No date fixed, generally it used to be listed on filing.
No show cause has been filed. In these two, both you have not filed in. Both the contempt petition concerning the forest department, that is contempt civil number 665 of 21 and 670 of 21. Stop. Learned GA1, Mr. Ashok Yadav, appearing for the officials of the forest department, has brought to the notice of the court an order dated 26 April 2022 by which the learned division bench has restored LPA numbers 479 of 18, 434 of 2018 and 480 of 2018, which were dismissed for default by order dated 6 January 2022. 20. Stop. He submits that says the stay was operating in the LPAs pursuant to the order dated 6 January 2020 itself. The stay order gets revived and the opposite parties are not under obligation to comply with the order. Stop. Para. Then counsel for the petitioner, Mr. Sauravaran, submits that the order of stay was conditional till appearance of the other sides. Stop. The writ petitioners had already appeared in the said LPA. Appear kar chuke. Therefore, the interim order had lost its force. Stop. Moreover,
In two cases, we have appealed.
which LPA?
LPA, LPA number 380 of 2018, Mr. Prasad Singh.
इससे ये दोनों कंटेम्प्ट अराइज हो रहा है. ये दो कंटेम्प्ट जिससे अराइज कर रहा है उसके एलपीए में आप अपीयर किए थे.
नहीं, उसमें appearance नहीं.
तो फिर वो
Mr. Prasad Singh batch matter, मेरा कहना batch matter है.
had the petitioners had appeared in the one of the latest patent appeal number
380 of
2018, which is one of the LPA in the batch matters. Stop. It is further submitted that the opposite parties have been taking time for compliance of the order and now a different stand is being taken. Stop. Then counsel for the GA1 seeks time to file a proper show cause. Stop. Para. It appears that one of the sister departments, that is RU, has chosen to comply with the order, and only allotment of the fund for payment of admissible dues is awaited, as already recorded above. Stop. The other department appears to have been buying time instead of complying with the order. Stop. The stand of the Forest Department, officials of the Forest Department, for non-complying of the order of the writ court dated 19 January 2018, for all along till the order of stay was granted on 6 January 2020 by the Learned Division Bench, and even after dismissal of the latest patent appeal till its restoration on 26 April 2022, defies reason. Stop. Our Learned Counsel for the opposite parties in LPA number item 11 and 12 are allowed 2 weeks time to file show cause in the matter of compliance. Listed thereafter. Presence of the officials is dispensed with. Learned Counsel for the petitioner submits that contempt civil case number
171 of 2020. 171.
arising out of which
Arising
WPS
out of
same in common in judgment
WPS number 6329 of
6329 of
2007.
may also be tagged together, as the order still remains to be complied. This relates to which department?
I.
Mr. Franklin Topo, Learned Standing Counsel, 7 seeks time to obtain instruction as regards the said contempt case. Let contempt number so and so be also tagged along with the instant case.
Item number 30, contempt 407 of 2019, along with item number 14 and 15. Mr. Anuj Barma.
The steps have been taken by the department to ensure what can to a letter which they have addressed to the University Civil Council. That they are informed that the receipt of that letter, but since the date fixation has not been done, therefore, you are not in a position to be. So at the day before, we have done the date fixation also, and forwarded to the university to form a business. The last affidavit.
You have filed some affidavit of OP number 2
Yes, no.
after the previous order.
Just after that, or 2 weeks more, we have done the previous session for all the business now.
OP number 2 in contempt civil 407 of 2019 has filed additional Chief Secretary, Department of Higher and Technical Education, Government of Jharkhand, has filed so cause in contempt civils 407 of 2019, enclosing a pay fixation, enclosing a letter letter dated 28th March 2022, annexure 1, bearing letter number 405, by which the pay fixation of by which the revised pay in fifth, sixth, under fifth, sixth, and seventh pay revisions of these petitioners, यही लोग का है, of Dr. A.N. Pathak and Rita Ray have been made and communicated to the Registrar Sidhu Kanu Murmu University. Stop. Mr. Singh, what payment has been made?
It is true that we have received the revised pay fixation of all the senior officers. But after receipt of the pay fixation, all the three petitioners are objected to the pay fixation.
And वो objection वगैरह तो that is an ongoing grievance of most of the petitioners. लेकिन आपको जो मिला है उसके बेसिस पर आपने इनका पेमेंट डिसबर्स किया है कि नहीं?
They have written back to the state government containing their objection that this is what they have objected to. And I talked to the university just before this report. They said that we are making the instruction what the government has to say about their.
देखिए यहाँ contempt में these things won't be decided.
Anyway, then in that case, I will instruct the university to make part payment as has been.
Whatever becomes due in view of this revised pay scale.
Some token payment.
नहीं token क्या पूरा?
We have not received any money from the state.
वो that's another issue. That they will say वो PLA account या क्या?
I thought they will not say it because they are saying that the total amount involved is 226 crores. This is one of their evidence for which they are going to finance.
अच्छा, this is that part payment. Oh.
I know this is a case.
अच्छा, this is that part payment.
I know this is a case in which similarly situated teachers in the entire state require something around 275 crores. Even if they say 226 crores, we are not objecting. And though they have said make part payment, we are saying that कुछ तो पैसा दे दीजिए हमको, नहीं तो ठीक है जो हमसे कहना है 1 लाख पर टोकन पेमेंट में दे दें, और बेसिक इशू ये इनको 226 करोड़ का मानते हैं वो तो सरकार दे, और ये अकेला मामला नहीं है, पूरे राज्य का लगभग इनका अपना एक्टिविटी है 226। Paragraph 5 of the counter has filed by OP2. Approximately 226 crores.
Provisional, this pay fixation of this petitioner, Dr. Naveen Kumar Singh, has also been done.
Yes, yes, yes.
Same letter. अच्छा 12. तो फिर उनका भी नाम लिख. And other such teachers, including petitioner Dr. Naveen Kumar Singh. Learned Counsel for the University, Mr. Dr. A.K. Singh, submits that the petitioners have raised grievances relating to their pay fixation. Stop. However, this being a separate issue, should not detain the officials of the university from making the part payment of the admissible amounts in view of the instructions furnished by the parent department. Stop. Learned Counsel for the university then seeks 2 weeks' time to ensure that admissible part payments are made. Part admissible payments are made to the concerned petitioners. Stop. Adjourned for 2 weeks to show compliance.
The next two matters are connected.
All submit order.
All three cases are connected.
Supplementary show cause item 13 में है, which covers item 14 and 15 also.
Item number 16, contempt 415 of 2019, Mr. Rakesh Kumar for the application.
Yes, Mr. K.K.
Substantial portion of the video. At least one is taking this application and agree on the communication.
What about your instruction?
So my instruction was that on the last second floor that I want to do 6 in this floor I have seen sometimes because compliance of the order regarding 15% it was completed because 10 years of service but not working on the science of presentation. I brought to the sent to the personal department, so now they are working to the home department. Now, today morning, you are asking, that they are at the verge of taking decision regarding these. So they are spending some time to
Since counsel for petitioner Mr. Rakesh Kumar is in personal difficulty, a prayer for adjournment has been made by Mr. Ashish Kumar. So accordingly, matter will be listed after 1 week. And counsel for the state, Mr. K.K. Singh, submits that instructions are being furnished by the department as to the compliance of the order in relation to the remaining 15 persons who though had completed 10 years of requisite service but were not working against any sanctioned post. Stop. He may also file supplementary show cause as regards the issue. That matter.
Item 17, contempt 531 of 2019, Mr. Himanshu Kumar.
When these complaints arise in the office of water, it is like 18, not even 9. But if I.
There was some SLP.
Yes, we have got this order.
Oh,
SSP and by order dated 22nd April, notice of issue notification.
impugned order means which order? Impugned order means CMP order.
CAP order.
If we are not being they don't use it.
CMP जो डिसमिस हो गया ना, उसी को वहाँ चैलेंज किया गया, तो उसका स्टे हो गया. What does that mean?
That means that the order is received in the vote. Right, the point is that the entire issue will be void on because it is contained in full. This to equate the quorum. We have changed. Otherwise, also I have to find person who is claiming for possession. He has sold out property to so many persons before that this decision was restored. And he is claiming, and in those children,
All that.
so but that those will be addressed in the main application.
What do you submit in view of this? Your party has already appeared there and accepted notice. We adjourn it for 4 weeks or 6 weeks. Then ASGI has placed the order dated 22nd April 2022, passed in special leave to appeal civil number 1770-1771 of 2022 by the Apex Court. Stop. The special leave to appeal petitions arise out of the final judgment and order dated 6 September 2021, passed in CMP number 282 of 2017 with I number 7440 of 2017 by division bench. Learned division bench of this court.
Yes, sir. The first time is a nature.
Division bench of this court. Stop. He submits that the operation of the impugned order has been stayed and the opposite party, petitioner slash opposite party has already accepted notice. Stop. In that view of the matter, then counsel for the petitioner does not dispute the submits that the matter is in session of the apex court. Stop. In that view of the matter, let the case be. The case is adjourned for 6 weeks or 8 weeks. Vacation listed thereafter.
Item 18, contempt 581 of 2019, Mr. Saurav Sekhar.
Yes. Huh? Are you appearing in this LPA?
We have been given 4 weeks time to file an affidavit.
Counter affidavit in LPA is not required. Your appearance is required. Have you appeared in this LPA 100? Petitioner and counsel for the petitioner submits that the writ petitioners have entered appearance in LPA number 100 of 2021 preferred by the appellant state. Stop. Learned counsel for the opposite party state, Mr. Mithilesh Singh. You are GA? GA4 submits that. Therefore, the matter may be adjourned for some time. Stop. When is it going to be listed, this LPA?
But it was to be listed after 5 weeks. We have submitted the exchange and notices have also been served. But by the affidavits are not compliant. So in the service of notice.
As such, the matter is adjourned for 4 weeks.
Item 19, contempt 689 of 2019, Mr. Fakama.
Actually, not like they're not able to do it. But that is the problem. Now they are very good, but they're not completely that way.
Perhaps this order was brought to the court's notice on an earlier date also.
Thereafter, we have find one opposite from again, this back continued.
Okay, so that reasoned order has been revised.
Right. Only one the state claim has been accepted. Claim has been accepted or that is ceremony. But for this state, and I have to get claim for that not there. I have article. Page number 30 allotted of the focus. This is the reason order, plus reason order. We just anything where you relate me, you keep it enhancement of the minimum qualification subject to the requirement लागू किया गया नेक्स्ट केस में यहाँ कॉपी कार्ड द्वारा लागू मान्य विद्यालय न्यायालय झारखंड के अंदर पारित न्यायालय से खंडन के आदेश मान्य विद्यालय द्वारा की गई ऑब्जर्वेशन में बनी वहाँ किए गए आदेश मान्य विद्यालय 11/30/2022 को पारित न्यायालय को ध्यान में रखते हुए सजा के मामले में विद्यमान अध्यक्ष को इस मामले में विचार की इसको कोई बात केवल देखते अध्यक्ष में लागू होगा ये जमीन का बाहर और
This is order passed in writ petition or review?
after about 3.5 years ago. 126 of 119 is a review. And this order has been passed in light of order passed in 24/8/180 in the case number 3282 of 2010. Thereafter, your order observed in contempt also in last order. Then this rest relevant has been passed. And we have
What do you say?
at least this is down for which that I will have to get this scale. Because why I is this clear, I is part of this routine. Because I have placed one from grade 1 to low, and it's on the board that is the schedule low. At this point, the date I now calculation from this, and that was not clear without also. और 11 के लाइन नहीं है क्योंकि इस डेट की और क्लियर ही नहीं है ध्यान लिखा पैराग्राफ 30 में देखा जाए तो रीजन ऑर्डर है डब्ल्यूपीएस नंबर 32 2010 में दिनांक 24/8/2018 को माननीय झारखंड उच्च न्यायालय द्वारा पारित न्यायाधीश के खंडिका 11 में माननीय उच्च न्यायालय द्वारा की गई ऑब्जर्वेशन एवं लास्ट वीक पर हम रिक्वेस्ट 14
अच्छा
क्लॉज 13 पर नहीं डब्ल्यूपीएस नंबर 32/2010 में दिनांक 24/8/2018 को माननीय झारखंड उच्च न्यायालय द्वारा पारित न्यायाधीश की खंडिका 11 में माननीय न्यायालय द्वारा की गई ऑब्जर्वेशन ऑफ खंडिका 12 में दिए गए आदेश तथा कंटेम्प्ट केस नंबर सेक्शन माननीय उच्च न्यायालय द्वारा दिनांक 11/3/2022 को पारित न्यायाधीश को ध्यान में रखते हुए श्री सलाह के मामले में वेतनमान इनकम बढ़ाते हुए वेतनमान इनकम की दावा को स्वीकृत किया जाता है।
स्वीकृत किया जाता है मतलब जब से फिटमेंट कमेटी का रिकमेंडेशन माना गया तब से
इस रीजन ऑर्डर में भी
2006 से
जो डायरेक्शन में 11 और 12 में जाएगा उसी का
हाँ तो 2006 से फिर मिलेगा ना
ये इसमें 11 में हम पढ़ लेंगे पेज नंबर 17 ऑफ द कंटिन्यूएशन so far minimum qualification for the post in question as the relevant time is concerned the petitioner has come up with a case that published working in other similar office having qualification of matriculation and getting pays of rupees 4,000 to 6,000 which has not been well denied by the respondent. Even otherwise also the petitioner acquired the qualification of graduation in the year of 2006. Hence as per the recommendation by the Honorable Justice Staff Army Committee, the petitioner ought to have been given the space of rupees 4,000
पैरा 12 तो क्लियर है कि जब तक न्यूनतम शैक्षणिक योग्यता में बढ़ोतरी नहीं होती है तब तक वेतनमान 3200 से 4900 लागू किया गया तो जब इनका 2006 में हो गया
ये बात को क्लियर किए हुए कि जो डायरेक्शन पैराग्राफ 11 और 12 में है that has been followed.
Then counsel for the opposite party submits that a show cause has been supplementary show cause has been filed on 30th March 2022 wherein you have revised your previous order.
Yes, we have order 24/3/2022. इसमें भी लास्ट ऑर्डर फॉर्म इनकॉर्पोरेट किए हैं पहले ऑर्डर उन्होंने लिंक उल्लेख किया हो पैराग्राफ 8 में बताया है पेज 12 पैराग्राफ 8
A revised order has been passed by the Secretary, Additional Chief Secretary, Revenue, Registration and Land Reforms Department, and it bearing letter number 184 dated 24th March 2022, Annexure 2.
Earlier order there was issued one.
He submits that the order under offence has been complied with and the admissible scale of that the scale of 4,000, 6,000 has been fixed in place of 3050-4590. Stop. It is submitted that a continuous reading of the reasoned order would show that petitioner would be entitled to the revised scale only from the date on which is minimum on the from the time when from the date on which or from the period from which he had enhanced his minimum qualification from inter to graduation. यही ना कहने का मतलब है वही पैरा 12 से ही पढ़ रहे हैं. In line with the recommendation of the fitment committee, para 38.21 of the fitment committee report of 2000. Stop. Then counsel for the petitioner submits that the admissible arrears may be directed to be paid from the due date in view of the revision of the pay scale. Stop. Consider the submission. Keeping into regard para 11 operative part of the order under offence. So, consider the submission of learned counsel for the parties and the last show cause filed on 30th March 2022, which encloses the 22, by which the revised scale of 4,000, 6,000 has been granted to the petitioner in place of the previous scale 3,050-4,590. Stop. Needless to say, the opposite, this takes care of the grievances of the petitioner in compliance of the order under offence. The admissible dues under revised pay be released in favor of the petitioner without any delay.
Are we subject to the outcome of the
Without any, उसको ऊपर में लिख दीजिए. This order, revised order has been issued subject to the outcome of civil review number
126 of
19. Within 6 weeks, preferably within 6 weeks.
Item 20, contempt 960 of 2019, Mr. Mahesh Tiwari, or the
As per the last direction notice, we have also by proposal on 21st April 2022.
क्या वो सब जो एक्सरसाइज करने कहा गया था हो गया? When have you filed, Mr. Dubey? 21st April. Which paragraph, Mr. Tiwari?
Paragraph 8. Paragraph 8.
बताइए, Mr. Tiwari.
Now your option, right from the year 2016 to 2020, this matter has been going. For the first time, by this so-called your object, they have stated that the land of the petitioner is not falling within the, your object is placing what they have stated, and the last 8 lines from the bottom at
You got a copy, Mr. Amicus?
No, that's this is I'm just going to.
No, it's a totally different turn of events now. So give him a copy so that he can assist the court. Assist the court both as to the turn of events and as to whether this latest turn of event is something which comes within the domain of disobedience of the court's order. Take it up
Of the
after.
court's order and continuous disobedience of the court's order, Your Honor.
This proceedings doesn't stop to surprise. Every time some different turn.
No, you are asking only, please allow me to read that. You are asking me.
I have read it. A supplementary show cause has been filed by opposite party number 5. Copy whereof, though has been served on learned counsel for the petitioner and NHAI, but has not been served to the learned amicus curiae. Staff learned counsel for the petitioner, opposite party so and so undertakes to serve it by tomorrow, a day after tomorrow. Stop. Matter be listed after 1 week.
Then I may be permitted to file a reply to this.
If you want to add to the pleadings, nobody stops you.
It has become so bulky that even I am taking questions, file or not. Because now it has come in our memory, in your lordship's memory also, all the sequence of events. Yeah.
Item 21, contempt 1185 of 2019, Mr. Kumari.
Yes.
Order has been complied with methods and we have filed our towards dated 25th March 2020. And we have brought on the record the resolution which was issued after the cabinet meeting.
So complied.
Yes.
The cabinet has given the sanction.
Yes.
Where have you stated?
Because we have annexed the resolution that was dated 9th of March. And that was clarified, we have stated that.
So now the consequential benefits have to be given by the university.
This session has not been done by the state. My convention, so why was it that the order has not come back? So let the state person. Just wanted to bring the every formality is being done by order.
Once the resolution has been passed, and it's to follow. Cabinet.
Which is the relevant part of the resolution which?
That is page number 13 of my Shubha's numbers, para 5.
Yes.
So the difficulty is faced by the department members, that is of the stated members. जिन व्याख्याता सहायक प्राध्यापक के द्वारा दिनांक 1/1/2006 के बाद PhD MPhil की उपाधि प्राप्त की गई है, उनको अतिरिक्त वेतन वृद्धि दिए जाने का प्रस्ताव सरकार के पास विचाराधीन था। विश्वविद्यालय अनुदान आयोग के पब्लिक नोटिस में दिए गए परिणाम स्वयं दिनांक 7/12/2018 में दिए गए क्लैरिफिकेशन पर सम्यक विचार किया गया। पब्लिक नोटिस के अनुसार the University Grants Commission has been receiving a number of queries from the universities with regard to admissibility of non-compounded advanced increments as well as benefit of number of years required for promotion under CAS to such PhD holders who have enrolled, registered, completed PhD degree before 11th July 2009. The Commission at its meeting held on 14th November 2018 considered the issue and approved that the non-compounded advanced increments to such PhD degree holders shall be eligible along with benefits of number of years required for promotion if the following conditions are met. PhD degree holder, the degree of the candidate was awarded in regular mode only. Evaluation of the PhD thesis by at least 2 external examiners. Open PhD viva course of the candidate have been conducted. Candidate has published 2 research papers from his or her PhD work, out of which at least one must be in a referred journal. Candidate has made at least 2 presentations in conferences, seminars based on his or her PhD work. A to E above are to be certified by the Vice Chancellor, Pro-Vice Chancellor, Dean Academic Affairs, Dean University Instructions. UGC के प्रस्ताव 28/2010 में शेड्यूल पर क्लॉज 6.8.0 की खंडिका 9.0 एवं यूजीसी द्वारा जारी किए गए पब्लिक नोटिस संख्या 16 ऊपर जो है 7/12/2018 में निहित शर्तों के आलोक में निम्नवत स्वीकृति प्रदान की जाती है। राज्य में कार्यरत विश्वविद्यालय अंगीभूत महाविद्यालयों के व्याख्याता सहायक प्राध्यापक जिन्होंने नियुक्ति के पूर्व यूजीसी के पत्रांक 16 दिनांक 16 के शेड्यूल पर क्लॉज 6.8 की खंडिका 9 में वेद शर्तों को दिनांक 7/12/2018 द्वारा जारी स्पष्टीकरण के आलोक में पूरा करते हुए पीएचडी एमफिल की उपाधि प्राप्त की है, उन्हें नियुक्ति की तिथि से क्रमशः 5 एवं 2 नॉन कंपाउंडेबल एडवांस इंक्रीमेंट एवं नियुक्ति के उपरांत पीएचडी एमफिल की उपाधि प्राप्त की हो तो उन्हें 1/9/2008 अथवा उनके द्वारा पीएचडी एमफिल की उपाधि प्राप्त करने की तिथि जो बाद में हो की तिथि से क्रमशः 3 एवं 1 नॉन कंपाउंडेबल एडवांस इंक्रीमेंट वैचारिक रूप से तय होगा। And then my looks, व्याख्या और सहायक प्राध्यापकों को वेतन वृद्धि का वास्तविक वित्तीय लाभ संकल्प निर्गत होने की तिथि से तय होगा। That is my looks on the date of notification, that is 9th March 2020.
Yes.
Can you see the order part that is on board, which is at least print? Now, first part, first bit I am skipping because it relates to another reason for it to be of local economy. My one is that next page, page 21, para 3 was psychological care. In WPS number 12, so the business and intelligence are placed for the following reasons. Number 1, to pass and set aside the decision containing letter number 2020/2013 issued by the Director Higher Education Government of Jharkhand branching responsible to number 2. To hold a declare that the respondents number 2 had no power of jurisdiction to withhold the PhD increments which were admissible to the petitioner by virtue of the combination of the two Judicial Committee report and the 6th Judicial Committee report in July of the UGC resolution dated 30 June 2010. To also pass and set aside the decision of the responsibility containing letter number 1 before the issue in pursuance of the decision of the government dated 26/2013. Now, in the rise of this UGC regulation 2010, the petitioners were getting this first PhD increments right from the beginning. This was challenged because these two letters were issued by them and they stopped that no, we will not be getting this. Now, finally, see the conclusion of this one. Ultimate paragraph was last one at page 25. In view of the reasons stated for the foregoing paragraph and as in the context of the aforesaid reasons and judicial pronouncements and as a possible secretary to the aforesaid reasons, the individual orders in the respective petitions are quashed and set aside with the also stands ground. So
saw that it is granted value given to it, they did not prepare any appeal for the appellate authority. Now they are sitting, here, if I may say so, as an appellate forum by passing this order over the judgment passed by this on court by saying many conditions they have imposed, but the one is अध्यापक को वेतन वृद्धि का वास्तविक लाभ वित्तीय लाभ स्वतः पृथक होने की तिथि से नहीं होगा, 2022 मार्च से होगा। तो 2022 के पहले हम लोग 2013 के बाद what will happen to this? The simple words, if I understand, the order is that
from when were you getting?
From this UGC regulation came in 2010, June 2010, 30th June 2010, and this specific date notes has also been given as to when they were appointed and when they are getting. They are getting for other years plus. And then they stopped it unilaterally, and when this one court passed that order, then they could have put us in the previous position, simple numbers. But now they are.
This resolution makes the grant of those increments conditional upon fulfillment of certain prescribed conditions, which may perhaps the regulation may also be prescribing, and also makes it effective from the date of resolution so far as the actual payments are concerned. So, as a result of the setting aside of the previous stoppage of increments order, the order granting the increments got revived. Now, instead of continuing with those admissible increments from that date from which it was stopped, this resolution makes it prospective and conditional. So, how is it in compliance of the court's order?
Since huge financial implications were my lord, that's why the approval from the finance department and then the cabinet was taken. And these conditions were brought forth by the commission when you received matters. And yes, this is a prospective matter. Since they are agreed by the if it should be retrospective and they will take the proper course. Substantial compliance has been done.
When the benefits were given to the petitioners, then the UGC regulations had already been accepted.
Yes.
Only then the state government started paying those.
Yes.
Because of that judgment which has been referred, Jagdish Sharma's case, so you accepted without any condition.
These conditions are the UGC matters. That is right.
Very well. So when you first accepted it, pursuant where you started resolution number 1188 dated 20th November 2010. Perhaps this was the date on which the UGC regulation might have been accepted. Acceptance was unconditional, with whatever stipulations the UGC regulation may itself have contained. Now, imposing another resolution to make it prospective or conditional, when your plea of financial constraint was not raised before the court when the petition was being decided, or carrying it further in the appeal or review, then you are circumventing the judgment and overreaching the judgment. This you will have to explain.
We have not before any appeal. The process might not be.
No, time, so one doesn't quarrel about, though it has taken a lot of time, but circumventing the judgment, how can you get over it? The list was not something which was not under adjudication. The list was not completely outside the precincts of any litigation or adjudication. So when the adjudication took place on the list and the court pronounced a view, then instead of taking a decision or making an order in compliance thereof, issuing a fresh resolution which in fact negates the import of the judgment. You, by virtue of this resolution, you are not going to resume the payments which were stopped, against which they came to the writ court. So how does the court's order get complied?
Maybe indicated in the order that.
No, if I start indicating it, right up to your cabinet will be in suit. Because this is something staring on the face of the order. Whether it is by a single bench or a division bench, the order is final. So all this which I am explaining it to you may have been understood or may have been unconsciously not understood by the department to have gone on to this extent. This resolution may have covered those persons who were not beneficiaries of that judgment. That could have been one.
Yes, sir, they are asking us 15 petitioners in this petition and 23 in the other petition. And also, factual aspects of each and every petitioner takes place.
What to be seen? They were all beneficiaries of an increment. Those were stopped. You lost at that stage. You said that show cause is required. The court said no show cause is required. Once that was set aside, then you come out with a different resolution and make it prospective. So, the writ court was not confronted with this stand of yours. No? Had it been confronted with this stand of yours, it would have ruled upon it, your way or other way. The position in law, as all counsels must understand, informed counsels, that you cannot snatch away the residue or ratio of a decision rendered in an adjudication. That's the beauty of this separation of powers and adjudication by an independent body like judiciary. You have to think over it, and either there is some explaining on this resolution itself which you may not have properly been briefed or understood, or
I had a discussion that even I was of the view that it should have been from 2013 as per the order. Balances thought this cabinet resolution had already been issued, madam. They had not consulted us before that. Because now, based on the matters, unless they challenge the notification matters.
no, the contempt is not over by issuance of this resolution. Because whatever was given to the petitioners has not been restored. This was not an order to pass a reasoned order pursuant to quashing of the order.
Yes, sir.
Both the writ petitions are allowed. You think over it. As the previous resolution of 2010, the foundation of the decision, has it been taken away by this resolution? You have to study this. Legislature is permitted to take away the very foundation on which a decision is taken by an amendment in future. That is something arguable or debatable thing. This Tribunals Act, which is being passed every time, Supreme Court is upholding, passing a detailed order that 5 years term of tribunal, one judicial member, etc. Every time that is being amended. Now this apex court says that you have not taken away the foundation. How can you overreach that? Appointments have been made with a tenure of 4 years now, but the main matter is still pending. Because the vacancies were being kept open for too long. Tribunals had become non-functional for too long. There is no easy way out of it. Either you convince the court on pure legal principles that this present resolution takes away the foundation. I mean, only suggesting some argument which you might perhaps float after due preparation. But otherwise, if they are not restored that benefits, this resolution will not come to them. This may apply to rest, but not those who have got the benefit of the judgment.
Yes.
If you say that this judgment was not in rem but in persona, think over it. This is no easy way out of it.
I thought that my friend will say that there is no apprehension. You are a lawyer, but what is there apparent we must disappoint.
Honestly said what I thought.
You just let go.
She said both things.
Disappointing. Fully. Provisions of advance increment for entry that PhD. Then comes 2018 references. When there is no provision for advance increment to a teacher who joins with their PhD or MPhil degree before the year. Now, if the cabinet resolution is put in force, then in 2022, that since 2022, 2018 regulations are there. There is no provision.
So better, I will not be able to appreciate piecemeal these things unless the main subject matter of the list, that is the resolutions, are brought on record.
Yes, I have not seen the notifications that we should pursue.
You bring on record or you bring on record, either party bring on record these resolutions. Your UGC resolution and those which resolution of the state government by which they were adopted.
Part of the otherwise it's part of it.
The writ petition is not before this court, no? This is only a contempt matter. No.
I said it.
A supplementary show cause has been filed by the opposite party number 2 and 3 to bring on record the resolution bearing number 305 dated 9th March 2022. Stop. Learned counsel for the petitioner submits that this resolution amount to compliance of the order under offence. Stop. Learned counsel for the parties undertake to bring on record the resolutions of the UGC and the state government adopting those resolutions, under which initially benefits of increment, कौन increment बोलते हैं उसको? Advanced increment. Advanced increment.
PhD and MPhil advanced.
PhD and MPhil advance increment were given to the petitioners but taken away in 2013,
Yes.
which led to the filing of the writ petition. So, the matter be listed after 2 weeks.
That's a pleasure.
Item 22, transfer petition civil 14 of 2020, Mr. Pankaj Kumar Mishra.
Pass over.
My lord, on the case, compromise is going on and almost terms have been settled. I have to transfer few times to the petitioner, my lord. I have applied to the circle officer for issuing a online no objection to the registrar's office so that I will execute this.
Deed of transfer of immovable property. Then counsel for the opposite party, Mr. Sajid Tushar, submits that the terms of settlement have almost been finalized out of court, and certain compliances are being made on the part of the husband. Stop. Therefore, the matter may be adjourned for 2 weeks.
After
Wait, 2 weeks to buy.
because they take time, my lord.
May be suitably adjourned. Then counsel for the petitioner also, what's your good name? Manoj Kumar Ram submits that when counsel for the petitioner is out of town, therefore the matter may be adjourned. In view of the submission made by London counsel for the opposite party, let the matter be listed after summer vacation. 22.
Item 23, contempt 694 of 2020, Mr. Dipankar.
Case in LP has been filed 69 of 2021, in which notices have been issued on the 22nd 12 2021.
LPA.
LPA. LPA query number 69 of 2021.
So this is the LPA is before DB2 or?
DB1.
When has been it issued?
Notice has been issued on 22nd December 2021.
Thereafter it has not been taken. LPA number?
LPA number 69 of 2021. We have filed show cause in which we have mentioned the LPA number at page 5.
So you have filed an IA also in the LPA,
We have filed
but any stay has not been granted.
and state as of yet has not been. Only
No one appears for the petitioner. Learned counsel for the state, Mr.
Sharad Kaushal,
AC2.
83.
She submits that notices have been issued in LPA number 69 of 21. On
22nd December
21. Stop. Therefore, the matter may be adjourned for some time. As prayed for, list the case after summer vacation 2022.
Item 24, transfer petition civil 14 of 2021, Mr. Vijay Kumar Sharma for the petitioner, Mr. Anil Kumar Sinha for the petitioner.
Mediation?
Mediation has been paid before the earlier trial put in maintenance case, not in this case. This case is arising out of the matrimonial package. My humble prayer is around that one more opportunity given at Dhamsa, so that my mediator, learned mediator would be able to translate both the parties' recent marriage in the appropriate time.
No, the transfer petition is pending since 1 year.
From marriage.
So it can't be kept pending. wife wants to be transferred from where to where?
Transfer from the
And is there any criminal case between the parties? Pending at Hazaribagh, Chatra. You have given the number. What do you say, Mr. Anil Kumar Singh?
My note there is note that is paragraph 12 of the petition you got. That's the petition. She has submitted that she got reasonable apprehension of ill treatment and danger of life. She goes to Ranchi at the hands of anti-social element and friends of the opposite party. Have these and this transfer petition. The file is the honorable High Court for transfer. Same apprehension is with the opposite party group, for which he has filed 2 transfer petitions, in one in maintenance case and in one in a criminal case for 98 euros. And the prayer of the petitioner is that it will be transferred at Ranchi middle of the Jamshedpur and the Chatra, and the petitioner is used to residing at Patna University, not at Chatra. I have the next mirror. I have the next three. Her journey ticket your lordship, page 53 and page 54. Whenever the date is fixed before we learn it for Chatra your lordship, she used to come from the Patna. She is residing there and working there.
Can your client come to Ranchi? Right? Then come to Hazaribagh? You will make payment for your
Yes, there is
attending the case at Hazaribagh.
But you also have to attend that very was in the relationship and the mediation was taken and under the 498 was already taken into
You have got any bail in that 498?
I have filed to pay before the session judgment and the same has been rejected. And I have filed 2 transfer criminal petition number 1/11/2021 and 4/2022 for transfer at Ranchi, Chatra to Ranchi. So I want to at middle place where there is no life threatening of both the parties, as he has stated in paragraph 12 your lordship. And after
you have filed any other case also?
only this one, the matrimonial taxes.
You have not filed any transfer petition for transfer of the maintenance case?
Yes, sir. I have filed transfer petition for maintenance case for transfer petition criminal number 4 of 2022 your lordship.
So that is pending?
Yes, sir. That is pending. That was listed before your lordship on 11/3/2020. And thereafter it has been converted. It has been, I'm sorry.
Transfer criminal will go before other bench.
Yes, sir. The transfer petition criminal was listed once on 25 to 2020 before your lordship, and thereafter by the order of your lordship, it has been converted in transfer petition criminal. Since it was arising out of the complaint case for 98.
Third Learned Counsel for the parties. Petitioner wife is seeking transfer of original matrimonial suit number 582 of 2020 instituted by the opposite party, husband under section 13(1) within bracket small I dash a of the Hindu Marriage Act 1955, seeking divorce from Learned Family Court Jamshedpur to Learned Family Court Chhatra. Stop. Parties got married on 30th November 2019 at Sonari as per Jamshedpur as per Hindu rites and customs. And as per petitioner, certain utensils, cash, etc. were also expended by her parents in the marriage ceremonies. Petitioner resigned from her job in a finance company at Delhi on pressure of the family members of the opposite party and his family members. Stop. Thereafter, she was turned out of the matrimonial home by the opposite party, and several utensils, passbooks, checks, etc. were also snatched. Stop. This led to complaint case number 255 of 2021, which is pending before Learned Judicial Magistrate Chhatra. Stop. Petitioner has also instituted a maintenance case under section 125 of the CRPC pending before Learned Principal Judge Family Court Chhatra, being maintenance case number 14 of 21. Stop. Then counsel for the petitioner submits that in such circumstances, petitioner may not be able to properly contest the suit at Jamshedpur, which is about 300 kilometers from Chhatra. Stop. On the other hand, opposite party has got to contest the proceedings at Chhatra in the criminal case and the maintenance case. Stop. Therefore, the suit may be transferred to Family Court Chhatra. Then counsel for the opposite party has filed a counter affidavit and submits that the criminal case has been instituted as a counterblast to the filing of the divorce petition on concocted allegations. And only 4 days thereafter, maintenance case has also been filed before Family Court Chhatra by the petitioner. Stop. Petitioner has also, opposite party has also sought transfer of the criminal case from Chhatra to Jamshedpur.
Chhatra to
Ranchi. Stop. Maintenance case transfer you have not filed.
In both cases, now that filed.
Separate petition. Separate petition.
My
What is the number?
lord, in maintenance case, transfer petition criminal number 4 of 2020.
4 of 2020. And
And in complete case, my lord, transfer petition criminal number 11 of 2021.
stop. दोनों का नंबर दे दीजिए. It is submitted that the opposite party also apprehends danger to his life and has therefore sought transfer of those two cases instituted by the petitioner at Chhatra. Stop. He submits that petitioner has been residing at Patna and commutes to Chhatra on the date fixed by the learned courts. Stop. It is submitted that considering the rival stand of both, considering the apprehension of the opposite party also, the matrimonial suit may be transferred to a neutral place somewhere in between Chhatra and Jamshedpur, so that both the parties may, without any threat or apprehension, attend to the proceedings. He submits that opposite party shall be willing and ready and willing to pay the expenses for conduct of the proceedings to the petitioner if the suit is so transferred to any neutral place. Stop. Then counsel for the petitioner has, however, expressed reservation to the transfer of the matrimonial suit to any other place other than Chhatra, to a place other than Chhatra, as according to him, petitioner may have petitioner may not a petitioner not being an earning not having any source of livelihood may find it difficult to attend to it. Stop. I have considered the submission of learned counsel for the parties in the background of the materials on record, materials placed from the record. Stop. It appears that though the petitioner has instituted two cases under 498A and under section 125 CRPC seeking maintenance against the opposite party at Chhatra, but opposite party on certain apprehension has sought transfer of those cases out of Chhatra. Stop. Jamshedpur and Chhatra are separated by about more than 250 kilometers, about 300 kilometers. Stop. 300 kilometers, about 300 kilometers. Stop. Considering the rival cases instituted by the parties and the apprehension expressed by both of them in attending to the proceedings at Jamshedpur or Chhatra, this court feels it proper to direct transfer of the original matrimonial suit number so and so to a place which is neutral to both the parties, that is Hazaribagh. Stop. Needless to say, on application being made by the petitioner, the Learned Family Court Hazaribagh would consider grant of expenses and cost of attending the proceedings as may be deemed fit and proper in favor of the petitioner wife. Stop. Accordingly, let original matrimonial suit number so and so be transferred from so and so Jamshedpur to Family Court, Learned Principal Judge Family Court, Hazaribagh. Stop. The petition is disposed of. You have already filed a matrimonial case there. अब तो इनके ट्रांसफर पिटिशन में हो सकता है वो भी हजारीबाग ट्रांसफर हो जाए. I don't know. We don't know. In this case, the court has fixed a neutral venue at Hazaribagh. उसमें लिख दीजिए Hazaribagh and Chhatra, for that matter, are separated only by about 50 kilometers. Therefore, it won't be onerous for the petitioner to attend to the proceedings at Hazaribagh. Before Family Court Hazaribagh, the expenses of which the opposite party undertakes to bear as well. Why? वो तो फैमिली कोर्ट फिक्स करेगी ना, वो
ज्यादा ही फिक्स करेगी.
वो उनके जुरिस्डिक्शन का मैटर है. कोर्ट ने अपना इंडिकेट जब कर दिया है आज के ऑर्डर में, तो यू विल टेक द एडवांटेज ऑफ दैट. Petition is allowed in the manner and indicated here in the book.
Item 25, transfer petition civil 21 of 2021, Mr. Anup Kumar Agarwal for the petition.
Last year, the respondent is planning to file you give that on my side, so I I have prepared all the things, but he is not come to share that. Mediation issue.
Despite
Both are residing at Delhi, both are working.
after failure of mediation, time was granted to file counter affidavit to the opposite party on the previous date, 25th March 2022, but the same has not been filed. You want time or you are ready?
I want that.
One more indulgence is granted to the opposite party to file counter affidavit as prayed for within a period of 2 weeks. Interim order dated so and so shall continue till the next date. Place the case on the Friday in the reopening week after summer vacation 22.
Item 26, transfer petition 22 of 2021. Mr. Vijay Kumar Rai.
This case it was sent for the mediation, but she did not appear due to the scarcity of money as well as the guardian situation. No one was ready to come with her for the mediation, so and child was in at the relevant date.
Court had granted 1,000 for each date. ये चल रहा है क्या ये वाला? कहाँ से इधर राइट साइड में हवा लग रहा है? सीधा लगता है. उसको बंद करिए तो. ये राइट कान जो है इसको बंद करिए. नहीं. From Chatra to Giridih.
Yes.
Any criminal case?
No, that is the divorce filed by the opposite party.
Marriage is of? No maintenance case also.
No, that is not having filed. Not of them have been filed. No maintenance case has been filed. She wants to live with him, but he has filed a divorce.
So your client has filed it at Chatra.
Yes.
Third learned counsel for the parties. Petitioner wife wants praise for transfer of original suit number 10 of 21 from Family Court Chatra to Family Court Giridih. Stop. The suit has been filed under section 13(1) within bracket small I-A of the Hindu Marriage Act by the opposite party husband for divorce. The marriage between the parties was solemnized on 29th May 2019, but due to marital discord and demand of dowry, petitioner has come back to her parental house. Stop. She doesn't have any source of income and is dependent upon her father. Stop. When counsel for the petitioner submits that it would not be possible for her to defend herself in the suit if it is not transferred from Chatra as being a lady without any sources of income. She may not, it is difficult for her to commute to Chatra and come back to Giridih, her parental place, on every date. Stop. Therefore, the suit may be transferred to the family court, Chatra. Giridih, yes.
There is threat to life of my grandmother, mentioned para number 11 of the affidavit.
Para number?
That the brother-in-law of the petitioner threatened severed and to the opposite party after refusing very Turkic languages and thereafter threatening his life. If you will not be perfect, I can give the written WhatsApp chat of. There is threat to life of my client.
You have not instituted any case for that. Counsel for the opposite party has filed a counter affidavit. Stop. He submits that the opposite party has apprehension of threat to life at the hands of the brother-in-law of the petitioner,
And the mother of the petitioner is also very important.
as also other family members. Stop. The opposite party is the only son of his parents whose father has died in an accident and his mother is ailing from several diseases. Stop. Therefore, prayer for transfer has been opposed. However, on being asked, learned counsel for the opposite party has not been able to show that any complaint has been registered in relation to such threat or apprehension to life. Stop. I have considered the submission of learned counsel for the parties and taken note of the materials on record. On consideration of the materials on record and submission of the parties, it appears that petitioner is a lady without any sources of income. Petitioner wife is living in estrangement with her parents at Giridih without any independent source of income. Stop. She may have genuine difficulties in contesting the suit at Chatra. Divorce matrimonial suit at Chatra, and the proceedings may not be properly attended. Stop. In such circumstances, in the interest of justice, let so and so suit be transferred from family court Chatra to family court Giridih. Petition is accordingly allowed.
Item 27, transfer petition 34 of 2021, Mr. Anurag Kashyap for the petition.
You are changing from this side to that side. Here also you have not filed counter affidavit. No further time would be granted.
इसमें जैसा आज का इन्फॉर्मेशन है एक लोग सेटलमेंट में जा रहे हैं और सेटलमेंट
ठीक है
म्यूचुअल ट्रस्ट इज गोइंग टू बी आज का जो कंफर्मिंग जो हम प्रेजेंट कर रहा है सो आज
So just not of the parents spoken to the said lawyer. He has not informed me about anything regarding it.
Any criminal case?
Yes, sir. This wife petition has filed on 498 case. I gave it.
You want transfer from Dhanbad to Giridih?
And you also will see para 9 of the petition. She is the only child of her parents. She is named with her parents, old aged parents. Father is aged about 72 years and mother is aged about 70 years. There is no.
Dekhiye, not learned counsel for the parties. No counter affidavit has been filed despite repeated adjournments granted on the request of the opposite counsel and counsel for the opposite party. After sufficient time granted to the opposite party. Stop. Petitioner wife is seeking transfer of the Matrimonials, original suit number 238 of 21 issued under section 12 of the Hindu Marriage Act 1955 for declaration of their marriage, his marriage with the petitioner as nullity from the court of from Learned Family Court Dhanbad to Learned Family Court Giridih. Petitioner wife, the suit has been instituted on grounds of mental illness, on the ground that the mental illness of the petitioner was not brought to the knowledge of the opposite party at the time of marriage. Stop. Due to marital discord, petitioner has been living away from at her parental place at Giridih and has also lodged a case under section 498 of the IPC, being Mahila PS case number 16 of 21 on 16 June 2021, where the husband has appeared. Stop. Plea for transfer has been made as she is without any sources of income and living with her old ailing parents, who are not in a position to accompany her to Dhanbad to attend to the proceedings of the suit. Stop. Learned counsel for the opposite party has opposed the prayer. He submits that to his knowledge, the parties are at the verge of settlement. Stop. However, no counter affidavit has been filed despite time taken earlier. Para. I have considered the submission of learned counsel for the parties and taken into note the materials from record, placed from record. It appears that the petitioner, being having no sources of income, so you have not denied it. No?
Yes.
May not be able to properly contest the suit at Dhanbad if it is not transferred to Giridih, where she is living with her ailing old parents. Stop. Opposite party has in any case got to attend to the proceedings of the criminal case of the Mahila PS case number 16 of 21 instituted by the petitioner at Giridih. Stop. In such circumstances, this court is inclined to direct transfer of original suit number so and so from Learned Family Court Dhanbad to Learned Family Court Giridih. Let the records of so and so be transferred from so and so to court to so and so forthwith. Application is allowed.
Okay.
Item 28, transfer petition 37 of 2021, Mr. Rupesh Kumar for the petition.
First time.
This will be the first time. Earlier also, the same party, with regard to section 9 petition, the second pass order. In that also, the status driver of it. Or this notice was received to the opposite petition to the respondent to the court itself. So the minute court.
What happened to that suit?
This is with regard to section 9 petition.
What happened? What happened to section? No, what happened to that suit at Dhanbad now? Issue notice on the opposite party under ordinary process, speed post, for which requisites be filed within 1 week. Stop. ऊपर में लिखिए, petitioner wife seeks transfer of original suit number 16 of 21 instituted under section 6 of the Hindu Minority and Guardianship Act 1956, instituted by the opposite party husband at family court Dhanbad, Kodarma, to the family court Dhanbad, where the since petitioner is residing in Dhanbad. Stop. It is submitted that earlier the original suit number matrimonial within bracket title original suit number 23 of 2020 issued by the opposite party husband under section 9 of the Hindu Marriage Act 1955 has been transferred to the Learned Family Court Dhanbad from Learned Family Court Kodarma by this court By order dated 20th November 2021, passed in transfer petition civil number 18 of 21. Stop. The suit is still pending. Stop. Issue notice on the opposite party so and so under ordinary process and speed post for which requisites be filed within 1 week. What is the stage of the suit?
स्टेट में उनको विवाद कर दिया गया है
Counsel for the petitioner submits that the petitioner has been debarred from filing the written statement as she is not able to appear on the date fixed.
As per the action given by this one report in that matter, we have already filed
In the meantime, last minute, further proceedings in original suit number 16 of 21, pending before Learned Family Court, Dhanbad, Kodama shall remain stayed. Listed on 17th of June 2022.
Item 29, transfer petition civil 42 of 2021, Mr. Kumar Nilesh of the petition.
marital situation, the post petition filed by the husband and the chief made down for chief of the justice is seeking transfer of the divorce from Dalwa to Dhanbad. So both the parties are permanent resident of Dhanbad. Despite that husband is filed in the post petition at Dalwa, deliberately was harassed away. Now see, the petition is also having a baby in her laps, and it's very extremely difficult and hardship process to attend the remote district at Dalwa. There are no direct communication except that some people tend to arrive at late midnight and more and more last mentioned that she has no source of income, fully dependent on her parents.
You want transfer from Gadwa to Dhanbad?
Yes.
Block?
Under your block.
Where?
Under the block in Gadwa, the portion is Dunia. These are in the same study. Come to Dhanbad. There is no direct process.
दोनों तो साथ में बहस करिएगा तो फिर क्या समझ ही नहीं पाए Let it come to Ranchi in between so that
he is resident of Dhanbad. Which is that he is resident himself, permanent resident of Dhanbad.
permanent resident
His village address is giving himself divorce. What is Dhanbad?
Where have you stated in your counter?
And earlier he was posted there, he was actually posted as Indian village. No, he has been transferred from that place. He has been transferred to that place. He arrived at all he has been transferred from that. And see the small baby also, which is extremely difficult to attend at Galwan.
Is it a love marriage?
No.
How can this court look into the WhatsApp chat?
These are the materials that came in the chat.
Petitioner on grounds of on grounds of adversity and lack of source of livelihood with a minor girl child to maintain, girl child born out of the wedlock between the parties on 25th March 2020 and क्या लिखे लास्ट में
and lack of source of livelihood with a minor girl child born out of the wedlock.
Minor girl child to maintain seeks transfer of original suit number 82 of 21 instituted by the opposite party husband under section 13(1) small I dash a within bracket of the Hindu Marriage Act 1955 to the Learned Family Court Dhanbad from Learned Family Court Gadava. There are no criminal cases instituted by the petitioner.
There is criminal case possibility.
लिखे हैं
लेकिन उसमें धनबाद में बिल्डिंग है, लड़के ने भी गाँव में काम किया, मेंटेनेंस के धनबाद में।
According to Learned Counsel for Petitioner, a maintenance case is instituted by her is pending at Dhanbad. Stop. Dhanbad and Giridih are not properly connected. Dhanbad and Gadwa are not properly connected and separated by considerable distance of more than 400 kilometers. Therefore, petitioner may not be able to properly contest the proceedings at Gadwa if not transferred to Dhanbad. Stop. According to the petitioner, the opposite party is financially sound and working as a junior engineer. Stop. His permanent address is at Dhanbad. Stop. Learned counsel for the opposite party has opposed the prayer and stop. A counter affidavit has also been filed. Learned counsel, he submits that the petitioner has never remained in the matrimonial home for more than 6 months.
1 month.
More than 1 month.
पंचायती बात हो गया आपका।
Stop. Despite efforts of reconciliation through Panchayati, she did not stay in her matrimonial home and came back to Dhanbad with her father. Stop. Petitioner, opposite party is posted at Gadwa, in a block at Gadwa, Bhandaria block at Gadwa, and may find it difficult to prosecute the suit if it is transferred to Dhanbad on the same grounds on which petitioner is seeking transfer from Gadwa to Dhanbad. Stop. It would be in the interest of both the parties if the suit is transferred to a neutral place falling in between Gadwa and Dhanbad, so that petitioner, opposite party may properly prosecute it and petitioner may also be able to attend to. Stop. Opposite party is ready and willing to pay the expenses, cost and expenses of the proceedings as may be deemed unfit and proper for such transfer to any neutral place. Stop. I have considered the submission of Learned Counsel for the parties and taken note of the materials placed from the court. It is true that Gadwa and Dhanbad are separated by a distance of about more than 400 kilometers. And there are no convenient means of communication. The wife obviously has to suffer more if she is compelled to commute to attend to the proceedings at Family Court Gadwa, being without any sources of income. Stop. Husband, on the other hand, is an employee of the state government and claims to be posted in some block at Gadwa. Stop. In such circumstances, interest of justice would be served if the so-and-so suit is transferred to Family Court Ranchi, which place lies, though not exactly midway, but at convenient distances from both Gadwa and Dhanbad. Stop. Opposite party, on application being made, the petitioner may, the Learned Family Court, Ranchi may grant suitable cost and expenses for attending to the suit at Ranchi in favor of the petitioner wife. Stop. In the aforesaid facts and circumstances, this court is inclined to direct transfer of original suit number 82 of 2021 from Learned Family Court Garhwal to Learned Family Court Ranchi.
Husband, he is a resident of Dhanbad.
Accordingly, नहीं, परमानेंट रेसिडेंट तो हम भी देवघर के हैं, तो उससे थोड़ी होता है कि हम वहाँ यहाँ रह रहा है जिसका नौकरी है. Accordingly, it is ordered. Accordingly, it is ordered. The application is disposed of.
Item 30, transfer petition 43 of 2021, Mr. Indrajit Sinha.
Yes.
Yes. Then file counter.
Counter you have filed.
File for transfer the original suit from Garhwal to Jamshedpur. 3 and 50 kilometers.
All your cases are at Garhwal.
And there are 2 cases pending. 498 case is also pending in Jamshedpur and the one maintenance case is also pending in Jamshedpur. There are 2-year-old child also.
What is your stand?
Yes, sir. My stand is also that without taking a single day of marriage of my children of Pakistan, and after marriage, the brother of this petitioner took 50 lakhs from his opinion. When this petitioner, when this OP asked to return the accounts, she went back to her tailor home and consulted and lost this case. And this document further see, to the graph the next document that see that always she was happy with this OP law, petitioner law. Several amounts were against the receipt document was conclusively since the date of marriage with this OP was being.
You have not refuted this allegation that 50 lakhs was taken from the opposite party.
The transaction is between the brother of the petitioner and this opposite party number 2. That is a business transaction.
Are they in business relationship?
Yes, Your Lordship. And for that reason, Your Lordship.
So you are saying it from where? You have not brought on record anything to this.
But the brother of the petitioner has also lost a complaint case against the
Is there that you file a reply to this?
Filed by this OP law against the brother of petitioner for return for payment of return.
Both of you are in business relationship?
No.
Have
The
you?
transaction receipt which we have annexed, उसमें भी यही purposes for business lordship. Kindly see there again.
He was continuously demanding money from this OP office for
They have transferred the amount.
never offered anything.
And the remark is that all the business lordship.
And when this OP stopped paying payment of money lordship, he instigated his sister to law the case.
You file your reply to this. Young counsel for the petitioner seeks 2 weeks and seeks and is allowed 2 weeks time to file reply to the counter affidavit of the opposite party. Matter be listed after the opening of summer vacation. Interim order dated so and so shall continue till the next date.
Item 31, transfer petition civil 59 of 2021, Mr. Siddharth Rai.
Transfer from Jamshedpur to Devghar.
Yes, sir.
Issue notice on the opposite party under ordinary process. There are 2 addresses.
Yes, sir.
At both the addresses of the opposite party under ordinary process and speed post, for which requisites be filed within 1 week peremptory. और नोटिस में ऊपर एंट्री कर दीजिएगा ऊपर वाले.
In this case,
No, अभी appearance के stage में है वो. Next date for appearance is 12th May 2022. Please the case on 17th June 2022.
Item 33 contains 631 of 2021, Mr. Asim Kumar Sahni,
It is coming for the first time. Order passed by this bench.
Yes.
Admitted dues.
That they can found that there is some complaint by the statement, some inquiry was done, and after inquiry they have sought opinions from our budget expectation, and they will take decision. That is in the law.
3 weeks time as prayed for is allowed to and council. 2017 का केस है.
Still we are writing to the
To file show cause in the matter of compliance. Please take care of.
Item 34, contempt 8681 of 2021. Mr. Pankaj Srivastava for the petition.
This is about the state commissioner to pass the order.
This was about regularization. So, what?
In the year of 2001, the PS 49 was voted on National 1 by 1/8/27. Lord Thereafter, by content. Measure 3 is that is already been controlled.
Achha.
Yes. Thereafter, again, this measure 5 is and said, you can see what it is 31.
So why have you filed again?
Since the matter was not disposed for seeking regularization, my lord, again a representation was given, but that was not decided. Therefore, my lord, this contempt petition was necessary.
Have you considered after the disposal of contempt?
Yes. We have already recommended to the commissioner, can you see my outlet paragraph 9 there? Paragraph 9, engage 9.
Deputy Commissioner is also a party.
No, the deputy commissioner is not.
He has represented before whom?
Before Eco Garma, elevator of forest land, this specific elevator of forest.
A show cause has been filed. A reference may be made to the order under offence at Annexure 1 dated so and so, which is the order passed in the case of petitioner. Annexure 1 by 1.
Yes.
Order WPS number 4942 of 2001 dated 20th September 2012, Annexure 1 by 1, and order dated 25th June 2015 at Annexure 3. No, Annexure page 40.
Annexure 3 at page 31.
At Annexure 3, order dated 25th June 2015, passed in contempt case civil number 554 of 2013 in the case of the petitioner. And the statement made by the opposite party, कौन से opposite party? कोई? At para 10 of the show cause dated 20th April 2022. Stop. Then counsel for the petition, opposite party shall seek instruction from the Deputy Commissioner Garhwa as to whether any decision has been taken on the proposal of regularization of the petitioner placed by the Divisional Forest Officer, Social Forestry Division, Garhwa, by letter dated 10 September 2015 to the Deputy Commissioner. And letter dated 1st February 2022. Reminder letter to the Deputy Commissioner Garhwa. Matter be listed after 3 weeks. Court is directing you that the matter be listed after 4 weeks.
Item 35, transfer petition 11 of 2022. Mr. Siddharth Rai.
Issue notice on the opposite party under ordinary process and speed post, for which requisites be filed within 1 week peremptory.
Item 36, criminal MP 663 of 2022. Mr. Rajesh Kumar Mata.
These are paid for extension of time to surrender to the court notice and granted and accepted to stationary officer subject to payment of 25,000 cash. There is some paucity of money, so it took one time. In 2 weeks, could not arrange. However, he has arranged now. If the colleagues are saying that in 2 weeks, there will be.
I have learned counsel for the petitioner and learned APP.
Yes, sir.
On the prayer, stop. Petitioner seeks extension of time period for surrender before the learned trial court of learned Subdivisional Judicial Magistrate Bermo at Tanughat in connection with Chandrapura PS case number 110 of 2021 corresponding to GR number 955 of 2021. In respect of which, by order dated 21st December 21, petitioner was granted anticipatory bail with a condition to deposit cash security of rupees 25,000 and other conditions. Staff learned counsel for the petitioner submits that petitioner could not arrange the money in time due to his precarious condition and therefore could not surrender in time. Stop. Petitioner is now ready and willing to surrender before the court, the trial court, if time is extended for a period of 2 weeks today, as he has been able to arrange the required cash security. Stop. Learned APP has opposed the prayer. However, on consideration of submission of learned counsel for the parties and the grounds stated in the instant petition, time for surrender before the learned trial court in terms of the order dated 21st December 2021, passed in ABA number 8467 of 2021, in case of the petitioner, is extended by a period of 2 weeks from today. So, the order dated 21st December 21 shall be read with the instant order. Let the UID card of the deponent Dilip Mishra, son of so and so, of of the affidavit filed in support of the petition be sent to the learned trial court for verification of his identity at the time of bail, at the time of releasing him on bail. उसमें इसके पहले लिखिए petitioner, the order dated 21st December 21, या छोड़ दीजिए बस इतना, ये लास्ट कंडीशन हटा दीजिए. Petition stands disposed of. Let both the orders be sent through fax. The trial court. Disposed of. हाँ, disposed of.